Good morning. Welcome to the Foster Swift Sports Talk podcast. I'm your host, Dave Russell. I'm joined with my co-host, Charlie Sarche. Today, we're joined by two special guests. Lexi Drumm is a recent graduate just this last May from the College of Charleston. She was the valedictorian of the Honors College. She was the captain of the College of Charleston women's soccer team. She has been accepted and will be attending Northwestern Law School this fall. And she's also one of the athletes that is part of the appeal of the House settlement based on Title IX. Welcome, Lexi.
Thank you so much. I'm really excited to be here.
We're excited to have you. Also, our other guest is Leigh Ernst Friestedt. She is the founder of Equity 9 LLC, a boutique law firm specializing in Title IX, women's sports education, and NCAA regulation. Leigh is a former Division I student athlete from Brown University. She was a women's lacrosse star there. She held all Ivy honors. She blends her athletic experience with top-tier legal and financial expertise. She earned her JD from Vanderbilt University Law School in 1996 and previously worked in mergers and acquisitions on Wall Street. Welcome, Leigh, and thanks for joining us.
My pleasure. It's great to be here.
We have a lot to talk about, and we've in previous podcasts have talked a lot about the House settlement and the unintended consequences of it, and in that. So maybe just kind of to start us off, if you two can tell us how you became involved in the litigation, and maybe give us even a Reader's Digest version of what the House litigation is.
Okay, I guess I can start with kind of how I got involved. So I was interning last summer at a nonprofit that does work with Title IX advocacy for female athletes. And I was tasked with looking at reports that schools would put out about how many athletes that they have per sport, or the allocation of funds given to each sport. And my job was to see, where there potentially could be a Title IX violation for schools and submit letters to the Department of Education. So I became really involved with Title IX work, and honestly, it opened my eyes to a lot of, I think, the inequalities that are present in collegiate athletics. And it was kind of simultaneously happening when the House settlement was starting to ramp up. And I saw that all the work that I was doing with looking at an individual basis for each school, and then seeing how the House settlement, looked like a massive Title IX, issue. And so I saw it as an opportunity to get involved and really advocate on behalf of female athletes.
Yeah, and just to follow up, just to be clear, Lexi is actually represented by another top attorney, John Clune, who I had the pleasure of meeting Lexi and John at the oral hearings in California back in April. But I got involved because obviously I specialize in Title IX work and look broader at college athletics. And when I started looking at the kind of the structure of the settlement agreement and starting to speak to some of the athletes that I knew, male and female, I play a lot of tennis at a high level, so play with some former college student athletes, and looked at their numbers. I knew Charlotte North, who is, for those of you who don't know, is literally one of the top women's lacrosse players ever to have played the sport. A little bit analogous to the Caitlin Clark. She's really helping to bring that sport to the next level. So when Charlotte and I took a look at her numbers, this is a woman who literally played 2 years at Duke, was the leading scorer, transferred to Boston College, won the NCAA title in 2021, repeat visit to the championship game in 2022, and basically was literally the number one athlete in women's sports. And not only that, at Boston College, she was the athlete of the year. So she was a better athlete and had more notoriety than their football and basketball players. So we took a look at Charlotte's numbers. The NCAA settlement was valuing her at no name, image, and likeness broadcast value, despite the fact that she had been on all these ESPN broadcasts and sold out NCAA championships and all the ACC championships. So she was excluded from any broadcast NIL. And then she was, for her athletic services, the other component, she was valued at $286 over her 5-year career, which we estimated to be 11 cents on the dollar. So at that point, we knew we had a big problem. And then in addition to that, Charlotte is one of the athletes who post-Alston, she went out and made her own third-party NIL deals, completely independent of Boston College. And she actually made approximately $600,000 through third-party deals in the 2 years after Alston. And her lost NIL opportunities was valued at $2,000. So I think you could see just based on those numbers that when we spoke to Charlotte, we knew she had some glaring deficiencies in her valuation. And then when we spoke to other female student athletes, it was very similar. Leigh Ernst Friestedt is another woman that I'm representing. She was the captain of the Georgia women's tennis team, and they just won 2 NCAA titles. And Mai actually had been sponsored by Fila and Nike and Dunlop even before she went to college because, tennis players are basically semi-pros. And she was getting valued at, I think, like $200 some odd for her athletic services. So we knew the women's valuations were really off. And one of the challenges of the settlement agreement is it didn't make those numbers clear. It was very difficult for people to understand what they were getting paid, how were they getting paid compared to other people. So one of the benefits of having been an attorney and having been in finance, I literally took all the legal documents and dug into them and tried to get a baseline for where my players were getting paid. And just rough numbers, for example, we think that, a football player at Boston College may have made all in around $150,000. And they're telling Charlotte that she's worth $2,300. So, that's just some round numbers in terms of how we looked at this. And we looked at this in the context of, hey, these are female student athletes. In theory, these payments would have occurred from the schools themselves. And, something that people don't fully understand sometimes is what is Title IX? How does Title IX work? And Title IX is actually, it's part of the Civil Rights Act. And what it is really is that universities, they receive federal financial assistance from the government. So as a condition of receiving that money, they need to comply with civil rights laws. And that includes Title IX, which basically says that you need to give women an equal opportunity to play sports. And to the extent you're going to provide them with additional treatment or benefits, for example, an athletic scholarship, or in the past, Alston payments, or the new model that we're moving toward, compensation, that those treatment and benefits, that financial assistance needs to essentially be equivalent. And so, that's the foundation of the law upon which the 4 women that I'm representing and the 8 women that Lexi Drumm is affiliated with John Clune, that they are all appealing to the Ninth Circuit based on Title IX.
Did Judge Wilkin address Title IX much at all at that settlement hearing?
No. My understanding going into the oral proceedings was that, unfortunately, Title IX was not something that Judge Wilkin really wanted to address and analyze on the merits of. So my oral hearing, I tried to go down explaining that to her, but it was very clear to me very quickly that she didn't want to go there. So I really tried to focus on some of the key concepts that I thought were really relevant in terms of what we were objecting to. And I realized during that oral hearing that, I wasn't going to win any of my arguments at that point in time, but I did at least want to convey to the court what our concerns were and was hopeful that they would go back and really take another look at these things. But unfortunately, they did not.
And just for our listeners' sake, I kind of want to go back. You referenced Alston, and I want to make sure that we talk about what that actually is. We really had this changing landscape from the Ed O'Bannon case, which I think was decided back in 2014, to the 2021 the Alston case, which did I believe that did have Title IX implications. And can you talk about that those two cases a little bit, and how we got to the point where Grant House files this lawsuit that gets certified as a class?
Sure. Well, I think what's really interesting too is Judge Wilkin actually presided over the O'Bannon case, the Alston case, when they were at the district court level, and now the House case. And what's interesting is all of these cases, they're actually an antitrust case. And so what they're basically saying is, hey, the NCAA has been colluding with the universities and the athletic conferences to basically create these rules and to enforce these rules that limited all male and female athletes from monetizing on their name, image, and likeness. And that is anti-competitive. Okay, so that's at the heart what the what this lawsuit itself is back. And just to be clear in terms of where we as Title IX individuals were running up to a roadblock was basically the court was saying to us, hey, this is a Title IX. I mean, this is an antitrust case. If you have a Title IX issue, you can deal with that in another court. And that, unfortunately, given the release that they were putting into the settlement terms itself, was not going to work because the women were not going to be afforded the opportunity to basically pursue a lawsuit unless they actually had opted out from the whole settlement. But stepping back to your question, O'Bannon, Alston, and the House case, they're all antitrust cases. And I think a lot of people know in Alston, the Supreme Court basically ruled that this whole monetary framework that the NCAA is operating under, monetizing off the backs literally of the student athletes, Justice Kavanaugh, in his concurring opinion, kind of took it one step more and said, hey, to everybody, like they were only able to really rule on a narrow aspect of the education-related benefits in Alston. But basically, Justice Kavanaugh said, I can see that this is going to be going down a bigger path and could foresee a situation which we now have in house where we're really challenging the viability of any of the student athletes being permitted to monetize on their name, image, and likeness. And so in Alston, what happened was that was when the floodgates opened up. The Alston decision came, the NCAA, the U.S. Supreme Court decided on, I think it was June 21st, 2021.
And that was 9-0, I think.
What's that?
And that was a 9-0. That was a unanimous decision, right?
That's correct. A unanimous decision, which is unusual. And the NCAA had an interim NIL policy in place by June 30th. So that was unprecedented in terms of how quickly the NCAA acted. And that's when the floodgates opened. And that's when the athletes were at least able to go off and independently get their own third-party deals, which, for example, is what Charlotte did, which, for example, is what a lot of the male athletes have done, and they've done them with collectives. And, that was releasing the floodgates in terms of the athletes finally being able to get paid. The difference here now with House is we're talking about the educational institutions themselves and or the conferences paying the athletes directly. So that's the next step that we're really looking at here in House that's kind of taking things to the next level.
And before we get there, I guess on the Alston, you talked about Alston payments. Now those are like Lexi in your during your time, were you receiving Alston money?
No, so during my time, I didn't receive any like explicit Alston payments, but I know there was like other athletes at my school that were. So yes.
Were you having any other experiences with NIL, any other NIL deals going on while you were at?
Yeah, it was mostly third party stuff and like very small. I would say at Charleston, I would say predominantly women's side of the athletic department really had to like figure NIL on themselves, like if they wanted third party. I know there was other athletes who had NIL deals facilitated for them, predominantly male athletes, but female athletes, it was mostly like third party, go find it out on your own.
And those were small businesses in the area that were interested in helping out?
Yeah, like local things within Charleston, which is like, being in Charleston does provide a huge opportunity for it being a metropolitan city, but yeah.
So, Leigh, I kind of cut you off there, but I did want to make sure that our listeners understood what that was. And so you were starting to talk about House and what the implications of House, what that complaint did.
Sure. So like I said, House has kind of taken the continuum of how are you going to compensate the athletes? And again, it started with the Alston payments. And for people who may not be familiar with that, an Alston payment was basically $5,980 that the universities were permitted coming out of Alston to basically pay directly to the athletes. And it was capped at that number. And then what Lexi was just describing and what I was describing with Charlotte was, in addition to that, the athletes were allowed to go out and get their own third-party NIL deals. So initially, the amount that the schools could pay them was directly $5,980. Give you an example. Two of my athletes are from Vanderbilt University, playing the women's lacrosse team, and then Mai is obviously from the University of Georgia. All three of those women did receive full Alston payments, $5,980 of cash going directly into their accounts each year. Charlotte North, who played on the #1 women's lacrosse team in the country, did not receive any Alston payments. And that probably reflected just more, I don't want to speak on behalf of BC, but basically that I assume that BC may not have been giving out Alston payments to all of their athletes. I don't know that. But Alston payments were not required. But we can see that started at called $6,000. Now we're talking about jumping to $20 million a year at these schools with house, which is, basically we're talking about the male and in theory some of the female athletes getting paid part of the revenue sharing that should be coming out of the monetization of these student athletes' services and their name, image, and likeness that is contributed to the packaging of their games that are then sold to these broadcast networks. And so the theory is that basically these athletes should be getting a share of that. If you don't have athletes playing on the sports, you have no product to sell. So it's completely reasonable for all the male and female athletes in Division I sports to think that they are entitled to a percentage of this money, because the reality is they are the product that is being sold.
And so as part of that litigation, the plaintiff's counsel and the NCAA come to a settlement, and then that's where they reach this approximately $22 million per school that they can share in revenue, correct?
Yes. So there's two components of the settlement. There's the back damages component, and that's the $2.8 billion. So that's supposed to cover all D1 athletes from 2016 to approximately now. So that's the back damages payment. Then there is also what's called the injunctive relief, and that's going forward for the next 2 years. And in the injunctive relief, there's two components. Number one is if a school opts into the house settlement, they are permitted to pay up to approximately $20 million per year to their athletes, however they decide to do that. Number two is that there actually now is what's called a roster cap instead of a scholarship cap on all of the schools going forward. So, for example, football may have had 130 players. They're now bringing down to 105. They have a roster cap of 105. However, they have basically said historically the NCAA had a cap on the number of scholarships that football could offer. They could only offer 85 full scholarships. Now they are permitted, if they wanted to offer 105 scholarships. Let me give you another example. Charlotte North played women's lacrosse. The only year that she was able to receive really a full scholarship was when she actually transferred, because lacrosse had a cap in terms of the number of scholarships that they were allowed to give a men's or women's team. It was approximately 11 athletes out of a roster of 30 to 40. So they gave what was called equivalency scholarships. So in theory now, under this new structure, top female and male athletes, in theory, could be afforded more scholarships to the extent they weren't provided a full scholarship than they had in the past.
And not to cut you off, but just for our listeners' sake, so they'd understand what this means. This means Charlotte North, who in my opinion is the best women's lacrosse player to ever play the game, who won the Tewaaraton Award, which is basically the Heisman Award for lacrosse in both men's and women's, wasn't even receiving a full scholarship for most of her time in college. So that would be, you think about the Heisman Trophy winner not receiving a full scholarship.
Right. And when you say not a full scholarship, I looked at Charlotte's numbers, but we're talking around 50%. And just to be clear, that was not the fault of Boston College. That was more just a product of, again, Acacia Walker had like the #1 team in the country. She's got to allocate 11 scholarships across 40 players. So, that's the realities of how this worked in the past.
So, Leigh, do you think that the new roster limits and the getting rid of scholarship caps is a good thing that came out of this settlement?
No, I think in theory, I do agree that the scholarship cap should be lifted. Okay. So I believe that all of the schools should be permitted to, in theory, provide all of their athletes 100% scholarships. So this concept of capping the number of scholarships on a team is something that I think is a good thing that they've lifted. In terms of the roster caps itself, this is not something that directly impacted my clients, but something obviously that, for example, my clients are concerned about their teammates getting cut. I think that tennis may be coming down to, I'd have to check the numbers, but call it 11 or something. But, our top Division I recruits getting cut because of this roster cap number. And that's something that I don't agree with, and I think is very concerning to not only a lot of the student athletes, but even to the coaches and the universities, because I don't think anybody wants to recruit in a top Division I athlete on a number one team in the country and have to tell an athlete, I'm sorry, we now have to comply with a new rule that's limiting the number of athletes that we can have on our roster. And historically, we had this many, but we've got to reduce it by 10, 15. And, some people are saying, well, you can just go in the transfer portal and transfer somewhere else. Well, you can't just go in the transfer portal and transfer somewhere else if all the other teams are facing these same limitations and also really reducing down the numbers of their rosters. So I think this is a big issue for both the men's and women's teams, and it's something that's playing out right now.
So, Lexi, were you one of the objectors of the settlement?
Yes. Yeah, I was. Yeah.
Okay. And what was the basis of your objection?
I think the basis of our objection was kind of more so discussing the specifics of the funds. So going into the athletic service compensation and the broadcast NIL, that was explicitly what we were objecting to. When the calculations were formed of how much money they were going to allocate, we said that these payments and these numbers that you created could have never happened because they're based on a world where schools are going to be able to pay their athletes this money. And if a school is paying an athlete any money directly to them, it has to be compliant with Title IX. And these calculations, were created in a world where Title IX didn't exist. And so we were saying that, these numbers that you've created, they're great, but they would have never happened. And so they're false and they're wrong. And they need to be recalculated with Title IX, applied. So that's kind of what we were more, I think, explicitly discussing within the realm of the settlement itself, the calculations with the monetary portion. But I think overall, our overwhelming just argument is just the frustration with the lack of, I guess, the lack of seriousness that Title IX gets. I think that as a collegiate athletes and the other 7 athletes that are along in our objection, we're all collegiate athletes. We've all seen that female athletes do not get the same treatment that male athletes do, across the line. We have people who are in the Power 5, or we have people like myself who are in a mid-major conference. But I think what's most important, and I think that's honestly what's been left out of the whole conversation of the settlement, is how Title IX, is a right that every athlete is entitled to. And it doesn't just benefit male athletes, and it should benefit both. And I think that people get really frustrated when they see, what Leigh and I are doing. They're saying, well, male athletes make all this money. What makes you think that you deserve any of it? You're not entitled to that. And I understand how that can be frustrating for someone who doesn't understand Title IX. But Title IX has, been a safeguard for all collegiate athletes for years, over 50 years now. And, that's great that, male athletes are, revenue generating and are bringing in a bunch of money to a school, but a school's also, has tax exempt status. They're not here to be, creating all these millions of dollars just for male athletes. That money might be made by male athletes, but it's coming into a school and it's supposed to benefit everyone because that's what Title IX says. And so I think that male athletes or just other individuals get frustrated because they forget about Title IX.
So is it your position then, from a payment of name, image, and likeness through this revenue share, that all athletes should receive the same amount of money? And, and it's not necessarily just talking about male and female athletes. So my daughter played lacrosse at Kent State around the same time that Charlotte North would have been at Duke and Boston College. She's at Kent State, a MAC school, fighting for playing time. In my mind, she was a great player, but she was not Charlotte North, and so sorry, Reagan. But is it your position then that she should receive the same amount in compensation during that time as what Charlotte North would?
Yeah, I think that's a really interesting question. I think that's kind of where the third party comes in, what Leigh was talking about with Charlotte North. I think third parties are completely dependent on the athlete. So if Nike wants to come and sign Charlotte North, then no offense to your daughter, but Nike doesn't have to come and sign your daughter. That's completely third party, and that's not up to the schools being decided. That's up to the individual athlete. That really is the athlete's, name, image, and likeness. That's individual to them. What our issue is when a school becomes involved, when a school is now making those payments to athletes. That's not third party. That's school to athlete, and that's where Title IX comes into play. So what our argument is, and we're talking about the broadcast NIL. So, schools are inking those contracts. The schools are benefiting and receiving that money. And so the school intuitively would be taking that money and paying the athlete. When that process happens, when that exchange happens, that's when Title IX comes into play. But if Nike's signing a deal for Charlotte North and giving her $600,000 and the school's not involved in that, it doesn't matter. Title IX doesn't apply. Does that make sense?
Yeah, I understand your position. And is that the relief you're looking for in the appeal?
I think that's why we're targeting the athlete service compensation and the broadcast NIL. Specifically in, my objection. Leigh also is very similar, but also is objecting on different standards as well. But that's why we're targeting those. So we're targeting the broadcast and the athletic service compensation, because those are the payments that are coming from the school to the athlete. So there's some other category called video game NIL. That's coming from a third party. That's coming from EA Sports or the video game developers that are benefiting off these athletes. And we're not objecting on those basis because that's a third party. The school isn't paying that to the athletes. It's the video game developers. So I think that it's, it can get really complicated. And I think a lot of the times it's just misunderstood our argument. And we look like female athletes who are just upset and frustrated and just want to take all the money. But that's not really I think, the case at all. It's all we want is Title IX, the law, to be applied. That's what we're asking for. We're not asking for a new creation. We're not asking for a new law. We're just simply asking for the law to be applied as it should.
So Lexi or Leigh, I guess you keep bringing up broadcast, the broadcast side and then the rev share side. Just to be clear, so you're talking about a formula, right, that values players, student athletes. And that consists of the game, you said, broadcast, and then another third piece?
Yeah, let me try to break this down. If I get too technical, just wave and I'll stop. Again, we got to stop. We got to step back and say, okay, there are two components of these past damages that the lawyers went out and created, and they were the name, image, and likeness component, and in that they created what they called a broadcast NIL, a BNIL formula. This is a completely fictitious term. Let's be clear. Okay, this was literally made up. And this BNIL formula was actually based on just regular season game conferences, and they were looking at those broadcast agreements. So they weren't even looking at the NCAA championships or the ACC championships where they have deals with CBS or ESPN, and they're taking all of the male and female athletes and packaging all of their name, image, and likeness rights together and all of their athletic services together, and then selling that for hundreds of millions of dollars, and also creating corporate sponsorships. What they did is they created this BNIL formula, and that's where you get this concept of football players getting 75%, male basketball players getting 15%, women basketball players getting 5%, and then all of the additional sports, which includes every single woman, with the exception of the 15 players that are on the basketball team, getting 5%. So to the extent there are any other athletes out there that aren't playing football or basketball, and you're asking yourself, gosh, why is my number so small? It's because of this BNIL formula that was created. And this BNIL formula was then applied to athletic services. So again, when you look at like Charlotte's North athletic services valuation, how can she possibly be worth $286 over a 5-year career at 11 cents a dollar? How does that even make any sense in this country? So basically, it's because they took this BNIL formula and they applied it down. So they only allocated out 5% for all of the additional sports. So the women really got marginalized there. And then what we're seeing on the injunctive relief going forward is we think that a lot of the universities are going to be applying, again, this BNIL formula to their revenue sharing payments. So again, that these revenue sharing payments will be justified based on the amount of revenue being generated by the football and basketball contracts, because those are the contracts that the schools are entering into. They're not entering into contracts for any of the other sports. And so that's the premise upon which we believe the injunctive relief going forward, the $20 million, why you're going to see, you might see 99% of the money going to football and basketball players, to be honest with you. And I think that's a bad thing for lots of other sports, not just women. But I think there's a much broader conversation there. But that's how the money is playing out. And again, what we're fundamentally arguing is this whole concept of this original BNIL formula that was done in a world where Title IX does apply. And again, you would never be able to they're literally giving $2.4 billion to men and $0.1 billion to women. Okay, a 3-year-old could tell you that's not fair. And let me just even take this another step. The women are getting paid approximately $100 million out of the past damages settlement. The lawyers here stand, and it's not me, to be clear, they stand to make north of $500 million. So one of the big contentions that we also have is that, the lawyers, class counsel, and the NCAA and Power 5 conferences, ultimately they went off and settled. And, that's something we want to see generally in litigation, because we don't want to have to go through all of these appeals and have it take years. And this has already taken years. But one of our concerns is that basically, as part of the settlement, the women's valuation completely got compromised. And that's where we lost all of our money. And that's where I think they threw Title IX under the bus. And, that's the heart of what we're objecting to and appealing to the Ninth Circuit at this point.
What do you say to those who are going to argue that, we're here in Michigan, so you take Michigan football, Michigan State football. Michigan State's football stadium holds about 76,000 people. Michigan's like 105,000 people, and each of their respective basketball stadiums hold approximately 15,000, and they're sold out. And because of that, and because of their popularity, they have those TV contracts, and therefore they are producing revenue for these schools, and they're going to say, well, of course they're going to pay those athletes more because they're the athletes that are producing the revenue.
Yeah. I think one thing is you have to understand, historically, they never even monetized on women's NCAA basketball. Okay. So let's just look at some basic numbers. I think it was like in 2022, Lexi, correct me if I'm wrong, but the NCAA championship game, women NCAA championship game generated, I think, 18.9 million viewers for the women. They only generated 14.5 million for the men. So this concept that people aren't interested in women's sports is not actually accurate. To the extent people aren't interested in women's sports, it's largely a factor of the fact that historically the NCAA and the universities and the athletic conferences have not invested the same amount of money. They have not provided them the same level of publicity, and they have not showcased them the way they've showcased the men's tournaments. So, I think it's very clear that women's basketball can make money. And, if you go to LSU or you go to South Carolina, or look what Caitlin Clark did, my goodness, at Iowa, you had people traveling all over the country to see her. Women's sports can make money if you decide that is what you're going to monetize. And so, even women's basketball is something that when they did not even monetize this sport until after Sedona Prince came forward to the NCAA. And it's just now that they're starting to restructure their ESPN contracts and contracts with CBS to basically really start to monetize that sport as an individual entity and even develop their own corporate sponsorships. So, I think, hey, I love men's sports, and I'm really not trying to take anything away from the men's football and the men's basketball. I think the issue here is hey, all of the athletes have been getting shortchanged. And, I think the goal is not to push us onto both, different sides right now, which I can see it's easy for people to see that in that lens. But really, to understand the broader issue here is that the NCAA, the schools, and the conferences have been monetizing billions of dollars off these athletes. And absolutely, men's football, men's basketball, they deserve a lot of money. But the women's teams also deserve money, and the women's teams also deserve to receive the same level of publicity and promotion, because that is a component of Title IX that historically has not been provided. And if you give them that, I think what you're going to see, and just look at women's basketball, for example, that they can make money. I'll give you another example. I was at the Liberty game last night, and Caitlin Clark was on the bench. Cost me $1,000 to get into a regular season game for women's WNBA. If I go to a Nets game, does not cost me $1,000. So if somebody wants to argue with me about how much, women's sports can make, I think if you give them a chance and you give them the right platform, they are willing to play, and they're willing to make money just like the men.
Well, and I think you're absolutely correct. I think there's a lot of support for women's sports. I fully support women's sports. My older daughter played at Kent State, and I have a daughter that's committed to play at Pitt. One of the things that I think could be an unintended consequence of the argument you're setting forth is, does it ultimately hurt some women's sports and other Olympic sports, non-revenue sports, if you will? Because if the split for revenue is equal, if it's really done that way, what incentive do universities have to not just say, okay, we're going to have men's football, men's basketball, women's basketball, and volleyball?
Yeah, I'm concerned that that's where we're heading right now, even before you give the women any money, to be honest with you, because I think the model that they have going forward is really trying to justify the bifurcation between a revenue-generating sport, which again in college sports is football and basketball, because those are the two teams that the universities and conferences have decided that they're going to create the contracts with and monetize. And the non-revenue generating sports, that's everybody else. And really, so this is where I think, this is going to hurt a lot of the Olympic sports, swimming, even things like tennis. I mean, all of these sports, I think men's wrestling, all of these sports are really, I want to say I don't want to say chopping block, but the reality is that all of these universities have been in the process of completely restructuring their athletic budgets in anticipation of, wanting to provide $20 million to their football and basketball players, in theory, to basically, create the best team possible, and in theory to create, a revenue generating sport, which is already going to exist, because it's really, they're getting the money from the contracts themselves. And you can throw as much money as you want at a ton of different football teams, but you're only going to have one national champion at the end of the day. So at a high level, I am very concerned about the viability of an athletic department's, basically their budgets and how they're going to really manage these additional costs. And I think that it's really going to come at the expense of not just women's sports, but more importantly to all of these other additional sports that are key components when you think about what is the role of sports in education, what is the role of sports in college. And I think that there are people such as Lexi Drumm and certainly my clients that still espouse to be what's called a student athlete, who really want to get a great education and recognize that less than 1% of these athletes are going to go on and be professional athletes. So, what is it that you want these athletes to get out of? And so that's a fundamental question that I think a lot of athletic departments, probably need to step back and ask themselves and be honest about. But that's a high level where we look at things right now.
So Lexi mentioned earlier that if the rev share contracts with student athletes were to be divided equally between men and women, that we could still have third-party NIL deals coming in to maybe fill the gaps and make up for some of that disparity that the popular athletes might see. My issue is, and I think Dave would agree as attorneys that are representing Division I college athletes right now, is that the College Sports Commission, as of recently, has been denying third-party NIL deals pretty frequently and on a pretty ambiguous basis, an arbitrary basis. So how do you guys see that shaking out? Do you think that that's going to continue to be a problem? That's probably going to be a separate lawsuit down the road.
I think it's a huge problem And again, this is where, I fundamentally think that the House settlement really isn't good for a lot of male and female athletes. I'm a huge fan of capitalism. I'm a huge fan of men and women athletes being able to monetize on their name, image, and likeness without the NCAA and the universities basically supervising and exerting control over, which is essentially what is absolutely happening with this concept of the Sports Commission and Deloitte coming in with some 12-point test that's undetermined. And to me, the value of an athlete is what a third party is willing to pay them. I'm sure 90% of Charlotte's deals wouldn't have gotten through. Look at Olivia Dunn. She generated, we think, $10 million, on independent third party deals. The value of the women's basketball players, Caitlin Clark, what she does, it's what another third party is willing to pay them. That's the value. And, this whole concept of all of these independent third party deals having to go through the Sports Commission, I think is really just a whole nother antitrust issue. It basically is putting a cap on what they can earn. And I think it's consistent with, unfortunately, what we were trying to address is this whole concept of the eligibility rules. And once again, they're putting at stake the athletes' eligibility to play if they violate these third-party deals out there. So I think we're just kind of coming full circle back. And I think once this starts to play out, I think you're going to see a lot of, male football and basketball players very frustrated with this too. I mean, I don't want to speak on their behalf, but I think you're quickly seeing that.
Well, as a litigator, I expect that a settlement agreement's going to end litigation. And what the settlement agreement in this case has effectively done is it's created a huge amount of litigation. I think everyone expected the Title IX litigation because that was an issue that was left open. But, what Charlie just spoke about, I think we're going to see litigation on that and a couple other fronts as well.
Yeah, and I think it's important to recognize here, it's not just women that are appealing here. I mean, I believe, Lexi, correct me if I'm wrong, but I think like the Florida State quarterback has appealed. I know some Olympic wrestlers have appealed. I believe O'Bannon's son has appealed. So there are male athletes that are appealing for different reasons. But I think, again, it's consistent with they're concerned about the terms of this settlement. And, we come at it from a different perspective. But at the end of the day, I fully understand why other athletes may also be frustrated with the terms of this settlement.
Lexi, what advice would you have to other female athletes that are either in school right now or about to be going into Division I college sports? What advice would you have for them who might be frustrated with where they're at and where the state of college NIL is at right now?
Yeah, I think the biggest thing is to become educated. And I think your school, unfortunately, isn't going to do that. I think that they're not going to educate you completely on Title IX or your rights better than you could go out and do yourself. I think that that's what I learned throughout this process. When I started my internship, I thought I knew what Title IX was as a collegiate athlete, living out, athletics every day. And once I actually started looking at the law and like the rights that I was entitled to, I quickly realized that I didn't know, what Title IX was or really the rights that I did have. And I started, speaking out about it. And it's crazy that it's gotten to here and, people are reaching out to me and, having this opportunity to talk about this. But I really feel like it's important to, know what you're entitled to and, stay confident in that. And I think with an NIL era, if you see your school, helping male athletes, or it doesn't even have to be male athletes, but just other athletes in general and not yourself or not your team, start asking questions. I think that's the biggest thing, and not in an attacking manner, but just raising curiosity, because sometimes you're learning like alongside your athletic department. Sometimes they don't know things as well. And it's not as great to be accusatory, but rather, willing to work with, whether it's athletic departments or outside, agencies that are coming in for NIL. I think just asking questions and not settling just for being oblivious to what's going on, because there is a real opportunity for female athletes to capitalize on a new NIL era. But, it's up to the athletes themselves, or not even female athletes, but other athletes themselves, to really, make sure that they're understanding this new era.
Yeah. Is Title IX litigation something you want to continue working on once you get out of law school?
Yeah, so I think that it's kind of, I never saw myself getting into any of this, but I think it's obviously something I'm really passionate about. I think we talk about being a student athlete. I think the biggest thing that we really haven't discussed, just how much of a privilege it is to even be in the situation. I've loved my experience at Charleston. My teammates have become, my family, my coaches I know would do anything for me. And so I think it's so important. I wouldn't be the person that I am without sports. And I'm so grateful to have even had the opportunity to play at the next level. It's taught me so many lessons. It's, made me into a person who can even like speak on this podcast and talk about this. So I think that's just, I don't know. I would hate to see, even athletes like your daughter, not have this opportunity going forward, or, female athletes or just other male athletes that are in revenue producing sports not have the opportunity. I grew up in a very, athletic family. My dad was a swimmer in college. My brother's currently a collegiate football player at the Division I level. And my boyfriend played college college baseball and is now playing pro. So I think that I'm not anti, male athletes. I've grown up around male athletes, people who I love dearly are male athletes. But I think, going forward, I want to make sure that, athletics is open to anyone that wants to play them.
So what is the status of the appeal? I believe you'll be in the Ninth Circuit. We talked about that, Leigh. Is that right?
Yeah. So status of the appeal is, like I said, there's several parties that have appealed at this point. As I said, John Clune has separately appealed based on Title IX. I think Molo's firm has also appealed. They may be doing roster cuts and Title IX. Again, my clients were focused on Title IX. For our schedule is that we actually appealed about 5 days later, I think, than John Clune. And so I know that our appellate brief is due on September 8th. So we're working really hard on that here. And I know John is working hard on Lexi's appeal as well. And so I think some of the other parties, their appellate briefs will probably be due later. But, we basically are going to be filing our brief, and based on that, then, my understanding is their clerks will take a look at that, and they usually line it up with a panel of 3 judges to be determined. They may or may not have additional oral hearings. They, in theory, could rule just on the briefs themselves. I would think that given the order of magnitude of this case, that they probably would want some oral hearings. But, this takes time, to be honest with you. It's not going to be solved anytime soon. So we are going to have to be a little bit patient here. And I think as this plays out, I think we're going to learn more about how the injunctive relief is also playing out. So again, that's something that my clients have been concerned about all along. So I think we'll continue to learn. And, as Lexi said, hopefully we'll all start to get a little bit educated about this together and really start to understand what the student athletes' broader concerns are, the men and women, and see if we can't collectively, with the attorneys who have appealed, hope to make this a better situation for all the athletes.
Good chance you'll end up in the U.S. Supreme Court, I would imagine.
Yeah, I mean, listen, I will say this. That's something that we've absolutely discussed with my clients. My clients are fully prepared to do that. They independently have their own careers, and I'm extraordinarily supportive of making sure that